All right. Good afternoon, everyone. Thank you for joining us and taking time off on your Sunday afternoon. Welcome to Lab DCP Expert Talk, Series 6. So today our topic will be Roadmap to Navigating Through International Forms of Building Contract. Okay, they are JCT contracts, FIDIC contracts, and NEC contracts. So today's session is more towards comparing the discourse in terms of contract administrative for these three types of contract. Okay, I would like to invite two of my mentors and distinguished architects with me, namely AR Adrianta and AR Rida. Hi guys. Oh yes, here they are.
All right. Hi, Desmond. How are you?
How are you guys? I'm good. Staying safe. Rida, how's the durian?
Very nice. Good season.
Okay. Very good. All right. Without further ado, I will introduce our guest speaker today. So our guest speaker today is AR David Yek. He is a PAM committee member. Okay, a bit about a biography on the speaker. So David, second area of practice besides architecture and ID is alternative dispute resolution, also known as ADR, in construction law and payment construction related matters. Okay, he set up his firm to undertake drafting of various building and engineering claims, advises on disputes arising from contracts, and potentially as arbitrator. Okay, with a diverse knowledge and experience in the built environment, he continues to investigate the success and failure of building, whether it's urban, cultural reference in his daily work, while submerging himself in the intricacies of human relations in project management, dispute resolution, while delivering and carving the urban spaces. Welcome, David.
Hey, hello. Welcome, everybody. Good afternoon and good morning to the other side of the world. How are you guys?
Good, David. Good. How about you?
Yes, good. Very good.
Wow, you look fresh, huh? Very fresh.
And very excited, An.
Very excited. Well, thank you so much. Thank you so much, David, to spending time with us. I mean,
No problem. I was told there was a number of our friends from the Middle East is joining us today.
Right. I can see on the screen the attendees list. I think one of them is from UAE, Abu Dhabi. Yeah. I think, because Rida told me that he wanted to invite you to share this segment. I think it's good things to know for our local architects, especially Malaysian architects, getting to know better about this building contracts in internationally. Yeah, Rida.
Yes, even in our Facebook now, there's a lot of attendees from Philippines.
Okay, cool. Mabuhay.
Mabuhay,
Philippines. All right. So the main objective, Rida, the reason you invite our special guest, Architect David Yek, the main objective here, Rida.
Yes, the main objective here is actually since now the world is becoming borderless. And then a lot of us been doing a lot of work internally. So we thought that it is good for us to actually learn contracts at a larger scale, where in the future, the trend will be collaborative works between countries to countries. Yeah.
Yeah, precisely.
Architect cannot work alone anymore. We have to work together and solidarity. Yeah.
Yes. In the meanwhile, I mean, for me, when I read through David's slides last night, I mean, especially for Malaysian building contracts, you know, at least we know the comparison, at least we know the holistic of this international contract. And then it's like references for us, you know, to gain more knowledge, more experience, from Architect David Yek. Right, Esmond, our moderator today, our host today, Esmond. So how's the flow looks like?
Thank you, guys.
So, all right. So I think without further ado, Architect Davids are here. So David's now together with me in PAM Council members. And then he also a co-chair for Alternative Dispute Committee, David? So I think it's we can't wait to hear your sharing platform here. All right, so shall we begin, Esmond?
Yes,
Yeah.
we shall. Everyone, today's topic will be a bit difficult to comprehend. So I hope you guys get a pen and a notepad to jot down all the important notes, because to me this is a whole new world, Okay, without further ado, David, please take it away and go for it.
All right. Thank you very much, Esmond. Okay, I need to share my slide. Wonder where can I share screen this one?
Right, you can share the screen now, right?
Can you see my screen now?
Okay, David.
Good. Just hold on. All right, ladies and gentlemen, there's a request from I think some of my friends who is watching through Facebook Live. Is the Facebook Live on at this moment?
Yes, it's on.
All right, thank you very much. Okay, let's begin. Okay,
Yes,
this
it
is.
is.
Yeah, it is. Yes, good, great. Okay, I take this opportunity to actually sharing some of the information on international standard forms of contract to our fellow architects and training architects under the series of this learning architectural practice. So as you know that we can no longer work in silo, we have to take into consideration that this pandemic has not actually make us further, but in fact pull us all together through this use of internet and also some IT technology. So I think this is a good opportunity for me to do a little bit of sharing. Of course, there may be a different level of spectator in this particular webinar. Some may be an expert and some may be a student. So the expectation may be different. But what I want to say is this roadmap to navigating through international forms of building contracts are basically giving you an introduction. So we may actually have to consider if anyone who wants to be serious about doing a little bit more detail on this, then we can talk about it later. So let us now begin our talk. Yeah. So like any talks that is grounded on law, so we have this caveat that this webinar is for educational purposes, not a legal advice. And should you need a legal advice as to the case you may have, kindly refer to a lawyer. And you are strictly reminded that any opinions stated herewith are the presenter's own opinion and shall not in any way whatsoever taken as a legal advice. And also any scenario presented which may reflect actual scenario you may have experienced is coincidental and has nothing to do with anyone dead or alive. And for that, I thank you. So I need to speak this out loud and clear from the very beginning, yeah? Okay, let's go to the scope. Basically, there are three parts that I will be covering today. Part one is basically telling you the overview of the construction law, which is your roadmap. Okay, I know that this construction law is actually a big issue. It's a big issue to be addressed, and it will never be covered in this series. Is one big thing to consider. But I will just briefly bring you through. And the part two is the various international contract that is available, which is actually acting as your vehicle. And the part three is the journey, where you actually drive this vehicle through the road, whether this road is bumpy or otherwise. Well, this is your roller coaster experience. So this is what makes applications of construction law via the international forms of contract becoming interesting. Yeah. So let's go to the next. So let's start with part one, which is the roadmap. Now in construction law, many people have many definitions of what construction law is all about. Is it really a statute? Is there such an act? For example, in Malaysia, there's an act of parliament that say this is a construction law. Unfortunately, you can't find that. So if not, what constitutes this thing called the construction law? Well, I would say that the construction law is basically comprising various of law, notably the law of obligation, which is contractual, and there is something called extra obligation, which is called tort or delict. So it's just like this salad bowl here. And well, you can have the body of knowledge of construction law from these various textbooks. Yeah, my favorite is this construction law by John Wolfe. It's simple and straightforward. Of course, you have the titans, you know, the Hudsons and Keatings. And of course, the new kids on the block will be the Julian Bailey's treatise, the construction law in 3 volumes. Yeah, so you can get this in the market. And when we talk about construction law, it's basically talking about obligation. It's always begins with obligations. The obligations of the employer, the one who commissioned the work, and the one who is going to pay for the work. And at the end of the day, he's going to accept the work. Then the next guy on the end of the line is the contractor. And he's the one who's going to possess the site, and he's going to want who's to be in to indemnify the employer, yeah, while working on site. And he has a deadline to catch and to complete the work in time. Then what stands in between are the consultant like myself, the architect or the engineer, who is going to certify payment, who is going to issue instructions, and what generally called to administer the contract. So at one point, you have to be a quasi-arbitrator, yeah. The word quasi comes into play because you are not entirely independent, but you have to be acting impartial, yeah. So the project has always this project life cycle that is from the start to the end. And of course, if there is defect, and construction defect is normal, you don't have it's very difficult to come by with 0 defect. It's unlike commercial goods, you know. You can have prototyping and so on and so forth, but in construction, you can't. You can't just say that I prototype a building and tear it down and start all over again. So you have to bear with the fact that you need to deal with defect. That's why they have these post-construction things to deal with. And a lot of problems that actually comes in regarding administration of contract is in between the start and the end. So some issues may happen in between, and things like delay, event, variation, and so on and so forth. So who is going to say who is right and who is wrong between the employer and the contractor? And the answer is you, as the contract administrator. You are supposed to come in and intervene. So the beauty of this salad bowl as a construction law is that the first thing you have to deal with is the law of contract. Now, this is how usually the textbook presents the law of contract. You know, you have the construction of the contract, you know, the one who offer and the one who accept, and so on and so forth. There's a legal relationship, the objective test of certainty, there is a consideration. Of course, there is also issue with third-party rights. And there is also the term of the contract. So this is how usually textbook will tell you about the law of contract. And in my book, this is what I would actually look for. And these are actually very, very important because a lot of things screw up because this item is not carefully taken care of, okay? Start with the 3P, the parties. Who are these people and what is their local standard? Are they a real person or are they somebody who is fictional? You know, you have to take that into consideration. So beyond that, the parties, now we're talking about the employer and the contractor. Are these contractor really a contractor or they are just a $2 company? So these are the things you really have to look at. And the property, for very important, the property you're looking at, which is actually the work, you know. Is this work in the first place has got approval from the local authority? If it's not, and the contractor comes in and do what's going to happen next. So these are the fail-safe mechanism you have to really consider when you look at the law of contract. So the 3P, the parties, the property, of course, the price. Is the price really fixed? Well, that will have to be considered further. Sometimes you throw in the variation, the price is no longer fixed. Then the next thing is the 4T, the terms. What are the terms and the conditions that comes in, the warranties and the innominate terms? And also the time. Every project has got a beginning and the end. The question always have the issue. Now, for example, different forms will take the beginning or the commencement differently. You know, some say commencement is the same as the site possession. Some say no. you know. So time, and again, timing. Timing is over here is relation to procedural notice, where some of the items or some of the rights will be waived if you have not given a notice in time. So there is something called precedent condition, you know. And when everything fails, or what we call the fail-safe clause, is the termination, and how to terminate, you know, how to repudiate the contract or vitiate the contract in that sense. Then we have the DEF square, where the dispute cause comes in. Of some forms will prefer multi-tier, which means to say you have to do this first before that, and so on and so forth. And the logic behind is sometimes extremely difficult to understand. And also some exclusion clauses, like the insurance, you know, you exclude some of your liability away. And the notorious force majeure, which we have seen very often nowadays because of the COVID pandemic, which entitle you to EOT of time, but may not necessarily on cost. So this is another gray area. And when we talk about international contract, the application of international law comes into play, whereby this issue of private international law of the PIL will be considered. So please do consider all this if you want to have your contract not to fail at the end of the day. And of course, if once everything has been planned for, but yet it fails, then the question of damages will come in, which is categorized into three types generally. The normal one that is occur naturally following the Halley and Baxendale's case. Of course, there is another one called the consequential damages, you know. Something happens here and ultimately you suffer there, you know. Then the damages, which is in penalties, in the form of penalties that the UK approach now is following the Cavendish Square decision, yeah, whereby you don't have to actually prove your actual loss to claim for penalty clauses. So these are the things that all the party has to take into consideration if you want to have your rights to be protected by the contract. And extra obligation will include the law of tort. Well, this is a duty of care and so on and so forth. Because we have these people in between, there is the consultant, either engineer or architect, that is an implied duty of care to be taken care of. But strangely, the position in Malaysia is quite different, whereby there is a contractual duty between the employer and the consultant, but not between the consultant and the contractor. In that situation, you might as well say the contractor are being hung to dry, you know. So it's a bit of a difficulty, because if you rely on the UK decision on TACRA, the TACRA decision says that there is a contractual relationship between the employer and the architect, so the employer can sue the architect. But that is a totally different contract if the matter was brought up by the contractor. There is no contractual relationship on that case. So the L3 case in Malaysia demonstrates that the consultant has no obligation to the contractor, unfortunately. But I think as the times goes, things may change, you know. So in law tort, basically we talked about the possibility of damages that may incur, and also the omission and third party that comes in. Well, the rest is basically a professional negligence, nuisance, economic loss, and of course, the damages in tort is almost the same with the damages in contract. Then we married both together. We have this species called the construction law, whereby the elements of construction and the law are married together. So you have the dispute resolution, you have the parties that is involved, the law obligation, the procurement and standard forms. So now you can see there is a game plan. You have a game plan to tell you the rules of procurement. You want to get something from somebody, there is a certain rules that both parties has to play. So this is where the procurement standards comes into the picture. And there is also certain thing that the contract may want to move away from the application of the strict law of contract and tort, which is, we call this structure. There is a mechanism for variation, for example. There is also a mechanism for granting EOT, for example. So there is also inclusion of a special class of contract is where we call it insurance. And of course, there is some orders to how the documents is to be compiled, and finally, how to discharge the obligation. And if everything turns out bad, then we're talking about the damages, EOT, and completion. Then you have very funny terms like practical completion. You know, why must completion have this thing called practical or substantive completion? You know, so these are keywords that sometimes doesn't make sense for people not in this particular industry, and that makes the entire construction law very, very unique. So as a matter of, as a contract administrator, you ought to build up a corpus of knowledge of this law with its relevant authorities, be it case law, statute, or reliable legal commentaries. Legal commentaries are those textbooks that I've shown you just now. So these are your arsenals to support your reason as why you had given such a weight to some arguments of the party and not the other. You know, as a contract administrator, we are always stuck in between. So we have to listen to both sides, not just one side. Although you know that the guy who pay you is on your one side, which is the employer, and the guy that you have to administer is actually a contractor, you still have to listen to both sides. But how will you weight, you know, the claims that is given by both sides? That's where your knowledge in construction law and also the contract comes into play. So this is the process of weighting the claims based on the law that holds. All right. Up to this stage, you are not so concerned as to what the standard form the parties employ, because the construction law applies generally. The construction law itself is the body of knowledge, and the standard form tends to shift the risk from one party to another. Thus, sometimes it deviates from what the law holds as precedent. You see? So the contract is where the non-mandatory provision of the contract or the law of tort is being changed, so that there is a shift from the risk of from one party to another. So, well, you have to know what you contracted for in the beginning. So in places like the Commonwealth country, the meaning of good faith doesn't really mean anything. But for places like the Middle East, where they follow the Sharia law, good faith is the overarching principle. So you have to understand between the civil law jurisdiction and also the Commonwealth. So as such, this standard form sometimes create novelty clauses that are meant to be tested in courts to set new precedent. And like I said just now, the case in mind, which is good faith. So example, this is what the law holds. The contract sums is the price of works remains fixed, subject otherwise to variation in relation to works on materials and price fluctuation allowed for in the contract. So the lump sum fixed price is a well-established method of construction contracting with its price certainty. So these are the things that is being referred to a case law by Goh Eng Lee versus Yeo Jin Kao 2016 in Singapore, for example. So this will give you the body of knowledge when you have to decide between the different claims from different parties. Then we look at the meaning of procurement. In this, it says that it's the process of finding and agreeing to terms and acquiring goods, services, or works from an external source, often via a tendering or competitive bidding process. Then you have the types. So in the industry, it's well developed that there are basically 4 types: the traditional, the package deal, the management contracting, and the partnership. We'll come to this later, yeah. Just bear with me for a moment. And as a contract administrator, you sometimes before you get the contractor in, you have to advise, being an agent to your employer, what kind of procurement routes best suited for your employer's commercial undertaking. So you have to have a scientific methodology, and by far some may consider, the Australian model may consider a matrix evaluation methodology, which I'm going to share later on. And that may involve multi-tier tendering. That means you don't just go one one steps of tendering and appoint the contractor immediately. You may go to do an invitation first and look at their pre-selection, then only you actually go for tendering. And this will govern which form to use. So there are actually forms that has been pre-designed to take into consideration this different way or different route of procurement. So the procurement routes commonly available now is the traditional, where you have the employer at one end and the contractor on the other. The one who is going to administer are the consultants. So these are the traditional procurement. There's a lot of case law on this. This is well accepted by everybody, you know, but then it's a bit slow. So, you know, people say you have to properly cook the design before you actually bring it to the site, and this takes time. Then because of that, people becomes a little bit more ingenuine. They think of a way out, and then they come to propose these special things called the package deal. You know, package deal where you can actually rope in the contractor and say, oh, employer, just say what you want and the contractor will take care of the rest. So this package deal is actually what is also commonly known as the design and build. Then you will have this management contracting. You know, sometimes employers, they are basically, before they become the developer, they are actually contractors. So they have the ability to build at the same time. You know, they own the piece of land which they want to build. So how to deal with this? So they have this subsidiary company that actually works as contractor and under the same corporation. So they practice this, what we call management contracting, whereby they are actually managing it. They are not actually doing it wholesale by themselves. They sublet all the important construction roles to all the other subcons. So this is the management contracting route. Then there is a new one, very, very interesting. And, you know, if you take the old paradigm to look at this new way of doing things, I can tell you, you will never accept it. So this new kids on the block, I call this, you know, is the partnership contracting, whereby you treat your so-called your contractor as a partner, as a joint venture partner, not as somebody else. And if there is profit generated from the entire undertaking, it will be shared equally or by maybe by some 60-70, you know, 70-30 basis. You know. So this is the partnership procurement. Of course, having said that, there are also other people who think otherwise and came up with different type of procurement route. We call this a bespoke or miscellaneous kind. For example, they just want to, let's just say you want to procure a service of an architect. So these are very bespoke, you know. You can write in any way that you want. So let's go to this traditional. Basically, the other word is called the traditional general contract. Well, in short, everybody knows this traditional general contracting. You know, you have the employer, you have the contractor. And the issue with this is that the design has to be cooked by the consultant. And when it is fully cooked, then you go for a bidding. But the good thing is when you do this kind of bidding, you get the most competitive price. Usually you will not, the norm over here is not to get the lowest price, but to negotiate the middle one to take the lower price. This is called negotiation in between. So there is a clear separation of design component and also the construction part of it. And it's sequential. You have to cook the design first, then only construct. The undertaken by the employer to solicit the bids, and also at the end of the day, the construction contract is awarded to the main contractor, and let the contractor also the ability to procure their subcontractors. And as it goes by, his name is traditional. We have seen a lot of problems relating to this kind of procurement, but yet people still can live with it because they know the solution well. They know before the case law, they just know what to do with this. All right. So there will be, the problem is when you allow the contractor to have subcontractors, sometimes you do this kind of forced marriage nominated, you know, you simply want your main con to marry themselves with another subcontractor of your choice. That is where things become a bit problematic. So there are certain forms that try to mitigate that by saying that, okay, instead of this one, we have a series of choice subcontractor for you to choose from. And also I've mentioned these advantages. There are some advantages, not say there's no, and the drawback, of course, if the marriage doesn't really work well, you need to renominate the subcontractor, and that takes additional time and so on and so forth. So, well, people say that this is a little bit too time consuming, but yet it is time tested, you know. Everybody is familiar with the process, everybody knows what is going to happen next. Well, there are also people still say that it is absolutely outdated, and you simply have to wait for the design to complete before you can actually construct. And there's one more important thing: there is no such thing as you know, contractors cost engineering element that comes into play. You know, sometimes the consultant may put in a lot of safety factors, and your structures become so heavy and so costly. But with the contractor, they have managed to get their engineers to come with a very innovative approach that can save a lot of money at the same time, still comply to the required specification. But you cannot bring in the contractor until the design is fully cooked, unfortunately. So come this label called the umbrella package deal. Some people call it turnkey, design, build, construct contract, and the EPC contract. Well, now it's available in standard form, and this package basically talking about design, manufacturing, fabrication, management, all in one concoction to meet the employer's needs. And with the onslaught of contractors from China, some of them may even come to tell you, we will take care about the financing as well, you know. So how nice, everything has been taken care of by the contractor. They even get to the extent of getting you the local authority approval. So if anything were to screw up, just one point responsibility, that is the contractor. Of course, you have these other variants, they call it turnkey, you know, the contractor undertakes building ready for use, which turnkey means turn on the key, which including all the ID, furnishing, so on and so forth. And to some extent, they may also build, operate, and transfer. You know, they construct everything, they operate, and then they transfer. This is where the FIDIC form actually come in. There is one FIDIC form that actually cater for this. There's this, especially government link project. Government just wants the policy to be implemented. So they will say, this is what I need. The contractor take care of the rest. So this is also through private finance initiative. The contractor will come up with their financing to complete the job. And with this is fast tracking, but then there is also some problem with that. Okay, package D is basically more simpler. There is only one point of contact, which is the contractor. The employer is only provide comprehensive brief, accept preferred design package, and also make the necessary payment. Contractors covers the rest, design, construction, finance, and even approval. So the consultants are basically appointed and possibly novated from the employer to the contractor. So the consultant is no longer just have to be responsible for the employer. Now he has to be really responsible for the contractor, because there is a contractual obligation via novation. So what is this novation thing? You know, novation basically the contractual obligation transfer to another. So it's to be carried out by a tripartite contract and extinguish the old existing contract and replacing with a new one on the same terms. The limitations are basically, although it's quite rare, is that if the consultant just refused to work with this batch of contractor, or he has experience working with them and he got bullied, so he said, no, I'm not going to agree on this novation, then there's no novation. Yeah. So it's very important to consider the law regarding this novation. Of course, the English law provided that novation transfer both the benefits and the burdens. while the difference between novation and assignment is the assignment only transfer the contract benefits. So that's why there is this term called novation. Well, package deals again is fit for purpose, fast track, and simplify a lot of contractual obligation or arrangement, especially to third party. Then again, the disadvantage is employer can't choose. The moment employer interfere, there's big problem, you know. So you can't say that the employer must can interfere and yet the contractor must take all the responsibility. And this is very noble in FIDIC contract actually. It does say that in FIDIC that actually if you have not raised any objection pertaining to whatsoever risk after you accept the tender, all the risk that comes into play you have to take, the contractor will have to absorb. Such a thing, you know, in FIDIC. Very interesting, yeah. But then of course, there's a lot of wave of objections from the contractors, and that I think make them to revise their contract, you know. So of course, when you say the employer's specification or employer's requirement, sometimes it's rather difficult to fix, you know, because it's construction, unlike prototyping. Along the way, you will encounter a lot of other problems that you have not foresee. So there is, and also through time, needs change as well. So as employer, sometime, you know, after it drags for 2 or 3 years, you may change your expectation. So things like that will come in and derail the entire nature of design and build. Management contracting is basically the scope of the work has been chopped into some small little packages. We call this the prime cost PC sum packages, and the one who manage all, we call this a project manager. But have you ever considered what are the obligation and responsibility of the project manager? In law, you know, what happens if things were to fail, and will you actually hang the project manager on the pole and let him dry there? Will there be any jurisdiction that has law that actually apply to project manager? Just like, you know, you architects, you have statutory undertaking, you know, to do certain things. Same like engineer, if the buildings were to collapse, he's the one who's going to get hung. But what about project manager? I don't know. Then you have this where the construction management, you are supposed to engage several specialists who deal this minor tasks of this prime of sum. In that way, there will be supposedly fast track construction. Yeah. So in cases like turnkey and build, operate, transfer, this is where it can be shifted to become a construction management procurement. Of course, the advantage is it's private funded, and the advantage of the design management scope is being separated again. And there is something called the back-to-back payment. So if the project manager get paid, then only all the respective trade contractors will be paid accordingly. The disadvantages, of course, is an avenue for political abuse and corruption, and also the transgression of good faith. I'm not so sure whether this kind of procurement is successful in areas like the Middle East, but it's a bit difficult to coordinate back in this country, Malaysia here. So because of there is the overarching issue of the cost and legal coordination, we're full of uncertainties. So it's not quite popular in that sense. Well, this is very popular in Hong Kong, I was told. You know, big projects in Hong Kong, they are going on to this partnership and collaborative arrangement, whereby the success of the project is measured on collective effort. It's not just the employer or the superhero consultant or the technical inclined contractor, but it's a collective effort between everybody. Yeah, everybody. And the entire contract itself is being drafted in a way that from the very beginning is a dispute avoidance contract. Can you imagine that such a contract actually exists? That before one undertakes a construction, is the contract itself from the very onset says that this is a dispute avoidance contract. Interesting. So there is many areas where confrontation is avoided. And there's no such thing as you or me. There's only we. Interesting. Yes, very interesting. So it's the abstaining from the inappropriate legal advantage. Yeah. So it's everything between, not between you and me, it's we. So if we screw up, we screw up. So it's a distinguished form of partnership, a legal entity. There are different variants. They sometimes call project partnering, which is the single project base. Strategic partnering, which is subject specific base, you know. And framework partnering, which has a time period base. That means to say is between this time we are partners. After that, we are no longer partners. So it's a framework partnering. And there's they use this basically generally for construction consortium and alliance where there is a shareholding that involved through a special purpose vehicle to carry out this project. Okay. So from this, there is a partnering charter where they say the overarching principle of good faith, for example. So these are the things that all the partners has to undertake. Of course, this kind of arrangement may not go well with certain country with certain jurisdiction, especially regarding competitive law and so on and so forth. So the form takes place by having this partnering charter that everybody must uphold. So there is a standard form of contract available, and there is a partnering agreement if you want to go into. Of course, advantages, you know, it helps with all this, and drawback is always everything new, you just do not know what is happening next. And we have gone through this. You can go through this, all the miscellaneous, whereby it's a bespoke contract. You just do what you want to do. Now, selection of procurement is actually based on identifying your objective and constraint. You select your criteria, what is more important to you and what is less. Then you weigh about all these criteria, and then you chart, oh, this is number 1, 2, 3, 4, 5. And finally, you review really this is how you want to go. And you arrive at a preference recommendation. I will just go through briefly. These are how the things is to be tabled in the matrix. And this is how you weight your criteria. And this is how you actually put in your thought of which comes first and which comes next. With that, I bring you to part 2, which is the vehicle. All right?
Wow, I see. Interesting, yeah, David, when you start to intro.
Yes, Adjudicator.
Type, yeah. It's very interesting when you.
Hi,
when you
yes,
yeah. Can you?
Good. Okay,
can
now
you
let's continue first.
Yeah, can you hear me?
Hello, Adjudicator.
Can you hear me now?
Hello, Adjudicator.
Wow.
You just got frozen just now from my terminal. I think my line is a bit unstable now.
Okay.
What were you saying just now? Sorry.
Can you hear me now?
Yes, I can hear perfectly.
All
well.
right. It's interesting when you start to make an introduction, various types of procurements, types of that. I mean, this is kind of a popular challenges. I mean, the contract, the line of communication, David, yeah, especially through the giving instruction. You know, David, giving instruction. So, is it like, for example, I give an example, must the engineers ask the permission from the employer to giving an instruction? David.
Okay, that question is very interesting, but can we just hold on a little bit more?
Okay.
Let me just do some very brief talk about just very, very brief exposing this just JCT, FIDIC and NEC.
Okay, go ahead.
Then I will come back to this question because this question is very, very important.
Yeah. Having said that, David, before
Yes,
we go
yes.
to the next stage, can you explain a little bit about this is very important because you explained about the contract construction management. That is actually the most important essence for all the architects to understand first before going to doing the procurement, right, David?
In actual fact, I was thinking of keeping that to the last because
I see.
that is the most prized things of this talk, you know.
Okay,
So
save
let's
the,
let just
save the
keep
best
that
for last.
thought
All right.
alive. Let's just keep the thought alive, and I will revisit back that.
Okay, continue,
And
continue.
yes. Okay, just very briefly, all right. There are basically three kinds of international form because JCT is actually local form for UK, but to us here, Malaysia is considered international. So the domestic UK is the JCT form, where even our local PAN form is modeled according to the JCT. Then we have this international favorite, which is the FIDIC form, which usually run by engineers because it involves a lot of highways, bridges, you know, infrastructure works. And again, like I told you, the new kids on the block, which is the NEC form, I find it extremely interesting. So I will share it a little bit in a while later. And JCT can take into many forms now. And this is how it looks like. So it's the best, time-tested, and most thing that is better with the devil you know than the angel you don't know, right? So this form has been notorious for, previously, is notorious for its farrago of obscurities in the way it's been drafted. So as time changed, it takes into DNB and so on and so forth, but it's very popular in Commonwealth and is adopted in many of the local forms of contract. So I will skip much about this form, although for Malaysia it's an international form, but in essence it mirrors the current PAN form. Yeah. Now, FIDIC is basically we have this the rainbow suites, owes to its color, and each of these purpose and has its own efficacy. And the more popular one will be, in my book, basically is the red and the yellow. And let's just sometime look at the yellow for some discussion. And this has been international origins and widely used in international infrastructure works. Yeah. Well, the differences are by its color. I will revisit this back again. All right. So, for example, the red book is basically like a traditional general contracting. The yellow one is design and build, and the silver one is turnkey project. The gold is the design, build, operate. The pink is the one that you get funding from other banks to do a project in somewhere else. And also the FIDIC green book is the short form of contract. The orange is design and build. But this orange has now been taken over by the silver. So generally, this is how they classify the colors. So they plan to introduce the FIDIC suit color by, this is originally what I did was I planned to introduce one by one, you know, based on the color, but it takes too much of the time. So I would prefer a dialogue like what Anne has mentioned to me. So the dialogue is still the best way. So the question now I can go back to Anne, your question, what is going to happen with instruction, right? Okay, giving instruction basically now. Let's think about it. What's the purpose of you having an engineer? Basically, you look at the engineer as a contract administrator. At one hand, the role is to give instruction, right? Then the question may arise that must the engineer ask permission from the employer?
Correct.
You know, so if the employer were to dictate everything, then what is the purpose of having the engineer in the first place? Different from what the JCT approach is. JCT will say the architect will need to give instruction, but the moment instruction is given by getting consent from the employer, that is something strictly must be avoided. Why? Oh. Because it brings in the question of the non-impartial of the contract administrator. You're being look at bias to one side, more towards to the employer rather than to the contractor. So you have to balance this kind of situation. But FIDIC makes it such a way that there are certain conditions whereby you need to get permission from the employer before you issue such an instruction. This is something very unique, you know, but they say it all out in the onset as a contract. If you agree to this, you have to abide by this game. You know, if you disagree, well, just change the clause. So contractor who enters into a contract with this clause in generally are prepared to accept the fact that certain instructions from the engineer must be consented by the employer. Does that answer you?
What are the example, David, for the thing that must be consented by the employer?
The one that is the more important thing is something to do with variation.
Right.
Something to do with VO.
Because the guy who's going to pay is from the employer. And you have to understand, FIDIC is broadly used in big mega projects, you know, and sometimes the funding is from overseas established country banks. So they really need to know for whatever that is to be expanded or, you know, additional funds that is required, you have to get consent from the employer.
So in that case, David, so coming back to the, if that you say that, where is the impartiality of the engineer?
Yeah.
Well, that's very interesting. Where is the impartiality of the engineer? There are people who ask me this question, you know, from the onset, you know, the engineer is the agent to the employer. So what are we talking here? You already know that they are the agent, so why are you complaining? Their fees are being paid by the employer. You see? So this is the reason why, as a contract administrator, even though you know the fact that you are being an agent, in this particular case whereby certain instructions, before you give, you have to get consent from the employer. You really have to draw a line between what you can and what you cannot do.
Oh,
fortunately.
David, just a bit of question because I'm a bit confused, like the audience.
Yes, yes, it's new to you. Yeah.
When it comes to dispute between the engineer, you know, and the employer, so does the engineer get determined first, and you know, how does this work, and where is the natural justice in this kind of a FIDIC contract?
It's very, very interesting. You just hit the nail at its head, you know. So now you have one hand that you actually need consent to do things, which doesn't sound right. Then on the other hand, the dispute clause did say that the engineer has to determine first if there is a dispute, you know. When both parties is having a dispute, now the one who comes in between them, the engineer has to determine. Oh. So in the face of the contractor, you think that, oh, this engineer is going to be slightly biased because his instruction is going to come from the consent from the employer. Yet you need to be determined by this engineer. This is the first gate.
Wow. Wow.
Yeah. So where is the natural justice? Unfortunately, you have by contractual, you have really agreed to this kind of arrangement. Yeah, so you just have no choice as a contractor.
So from the offset, need to be very clear on, you know, the responsibilities of the engineer, employer, etc. Yeah,
the responsibility is actually spelled out in the beginning very clear. Each the employer's responsibility, the engineer's responsibility, and the contractor's responsibility is spelled out very, very clearly.
Yep.
And one of the things that I think is very novel in the sense that. Like I say, for certain things, the engineer has to get the consent before he can issue the instruction.
Okay, wow, interesting. I hope the audience got a bit of the gist there.
But whatever it is, David, it's the same, right? Instruction must always comply to the contract provision, right?
Yes.
You cannot go out of the contract provisions. Yeah,
so to speak, he has already written in that way. So the contractor must accept the fact that engineer needs employer consent before issuing EI. So it is stated like this. You just have to follow the provision.
Oh, now I'm
so you can see there's a shift in the risk. You notice that?
Yeah.
Yeah. In the general essence of the law, it says that, you know, he's free. He's just supposed to be impartial and give instruction without actually getting consent for anybody. But then the contract somehow shift the risk. Now go from the employer, now go back to the contractor. So that's the beauty of it.
What happened, David, if the contractor just simply ignore and refuse to abide the EI? What happened?
Now this is quite a tough question. You know, when you are being caught in the situation where the engineer gives you an EI that asks you to do certain work that you simply refuse to do, is there any provision in the contract that can say that the contractor must refuse the instruction given? At this point of time, they can actually ask the engineer to relook back based on his reason, all right? To actually look back the situation whereby the contractor feels that they cannot continue with this particular instruction. But then remember, there is also a provision in the FIDIC that says that after consideration of that request, the engineer can actually say to continue with the instruction, or he can actually retract the instruction. So the question now comes to the mind is, what if he adamantly says, you have to follow that particular instruction?
Wow. Oh, this is very new to me, guys. I think it's also very new to the audience. So in some jurisdiction, the engineer has no fiduciary duty to the contractor. Is that right?
Yes, taking that into consideration, like for example, in this moment in Malaysia, one of the judgment from the court is that there is no contractual obligation with the contractor. Therefore, yeah, yes, basically no responsibility for the contractor, even if he were to make a mistake.
Wow.
I see.
Leisure.
Great. So, okay, before you go further to next slot, I think Esmond, we got a question from all the way from Penang here, Adeline Chan. If I'm not mistaken, she's from Penang. Okay, can you read the question there to David?
Okay, I'm not sure if the audience can see, but I'll read it out. Question number 1, would package deal, such as BOT, preferred by the employer, also known as developer? That's the first question. So does the architect still play the role as contract administrator, David?
Very interesting. Okay, yeah, depends on which form you are talking about, FIDIC, right?
Yeah.
Now let's just assume that you are doing this BOT, and the architect is named as the contract administrator. If that is the case, then he has this role to play. Because ultimately, build, operate, transfer is this. The contractor has the obligation to first build that facilities, right? Next, then it will operate the facilities. After a certain time, then it will transfer back to the government. Now, as a contract administrator in the form, very interesting. The whole thing is separated into two parts. One is the build, and the other one is the operate. So the operate, there is a maintenance period. You know that. So that is where your duty also include into it.
Wow. So you need to factor in the cost, etc.
Yes, correct.
Okay. Adeline has another question. Just now you mentioned the partnership and collaborative contract is very popular in Hong Kong, right? So any sample or portal to read about this, you know, they might want to have some knowledge on this partnership contract.
Well, there's definitely the portal. You can always Google NEC, you know, you just Google NEC contract Hong Kong. They will tell you a lot of success stories of the schemes employing this NEC form. You know, this is always related to these big schemes where there is a joint venture between the governments and also private sector. So they are operating on a totally different level. You know, it's really a partnership level. It's not the adversarial like we're talking about here in FIDIC. We'll come to that later. Yeah.
Okay. All right.
Wow.
Yeah. David, there's one question from Facebook. Asking about in certain conditions of the contract, employers tend to interfere. They want to give employers instruction. Is This is captured in some of the international contract.
I know that is coming, okay?
Employer's instruction, Rida.
Yeah, employer's instruction, because this create a lot of conflicts, sometimes.
I know that is that will be coming, yeah. But let's look at. I will reserve that because this is a very one peculiar point whereby it's not so difficult to answer if the procurement is traditional, but it's extremely difficult if the procurement is design build. Yeah, I will take that later as I come to this. Yeah.
Don't forget,
Yeah. So there was also a time, let's just say, you have to get consent from the employer to actually give instruction, right? But in this case, let's just say the engineer is so impartial that he said that I refuse to give instruction. You know.
Yeah.
I don't think it's fair for the contractor, so I refuse to give instruction. Then what is going to happen? So, can the employer actually decided to terminate the engineer? You don't give instruction, as an employer, I'm now terminate you. Okay?
Wow. See, guys. FIDIC has very different way of what you call contract implementation. Okay. Without maybe we will touch a bit on part 2, David, which is a bit on the variation. Maybe David can continue on his slides. Okay, please take it away.
So we are talking about giving instruction, right?
Yep.
All right. Or variation, sorry, I'm a bit confused. Now let's just go through the process here first, can?
Okay.
Maybe you can carry on with your slides.
Yes. Okay. Let's just say that in this scenario whereby the employer decided to kick away the engineer, the old form allows that to happen. But that is very damaging to the contractor. So now there is a change in that. The FIDIC taking that into consideration. They put in the additional safe clause measure. You can only terminate the engineer with the consent of the contractor. Rida, are you saying something? I can't hear you, Rida.
No, I'm not. Yeah, I'm thinking, because when you ask this question, what if the engineer refused to issue the EI?
Yeah.
What is the? If the engineer is not around, so he obviously he won't be able to give the EI, right? But what's toying in my mind is actually, what if the employer actually give instruction to the engineer and engineer doesn't want to follow the instruction by the employer? Is that those ground for him to terminate as well? Because these are probably no provisions in the contract.
This is why it's stated for convenience. At any one time, if the employers decided to terminate the engineers, what are the provisions available in the FIDIC contract? So previously, he's entitled to terminate the engineer, but in the new amendment, the consent from the contractor has to be obtained. So it's rather difficult to terminate the engineer. Unless the engineer is so screwed up that both parties think that the contract will move better without the engineer, then by all means, go ahead.
There's a question from the system by AR Elena. She's asking, under FIDIC, would there be an automatic termination of engineers?
No. How to say there's an automatic termination of the engineers?
Unless the engineer is pass away lah.
Yes. Of course, there is certain conditions where is not incapacitated to actually move on with the contract. Maybe he got COVID and never recover.
Incapacitated,
Yeah.
David, hold on, David. There is a question from Rachel, David. From the system here, David. Maybe Esmond can read it.
Okay,
Desmond?
question from the floor. I think this one quite straightforward. So in a local context, let's say Malaysia, is it common for architects or consultants to advise on which type of procurement to adopt? Or is it usually decided by the employer / developer / paymaster?
Okay, now this is something I think I also ought to address, is that as an architect, we actually have taken away a lot of our traditional role and pass it to somebody else. In this case, when the contract is concerned, we have already taken this role and pass it to the QS. Most of the job that we see today is especially bigger scale. You will find that the QS will come in and help the employer to do the tendering processes and so on and so forth. So they are actually the professional who is advising as to which procurement road to take. And the architect is just being, not to say do not know what is happening, but they are just being informed. At the end of the day, the employer will say, okay, let's do this. And what can the architect say? So a lot of this traditional role of the architect is being removed on that ground.
Okay, wow. Rachel, I hope you get your answer. Anyway, David, maybe you want to continue the next part of your talk?
All right, let's continue on this. So what can the contractor do to avoid complying to the EI? So this is a very novel question. If there is a certain, you really have no choice but to comply, there is actually certain area that the contractor can consider, you know. And this is where claim consultants comes in to actually help the contractors to look at these various area, so that you don't actually have to follow the EI by counter-proposing certain things for the engineer to reconsider his decision. And one of the most common ground is the variation. I think variation you were saying, Esmond, you were talking about, right?
Yep.
Yeah, so I think you have a question to pose to me, just that I haven't covered the 2 little item.
Yeah, we have a question from the floor here, okay, about variation, since you're at variation, but maybe I'll raise it up, keep it in mind, audience, then maybe you can answer it later. Okay. So variation, because just now it related to the instruction, so it relates to variation. So variation is like, what if the contractor refused to do the variation? So guys, keep that in mind, the question. Maybe David will answer it later. Okay, but David, please take it away. Let's go.
Okay, let's just say that the contractor in the beginning has already delayed on his own doing. Let's just say he's supposed to do one stretch of highway, let's just say 300 kilometers highway. Then his progress of work, he already delayed. Suddenly you come in with a variation and ask him, give an instruction and tell him, now you have to connect, instead from A to B, you have to connect C, D, E, F, G, you know. Suddenly he was like, oh gosh, what am I going to do now? So these are the situations whereby the contractor may want to refuse variation. Or there are also situations whereby, you know, after taking on this job, there are more lucrative job somewhere else which the contractor intend to take. So he will just think about, okay, let's finish this job, at the same time I can start doing some other jobs elsewhere which is going to bring me more profit. So can I not do the variation? So you again have to fall back to the question of construction law. Must the contractor take additional job, even if it's instructed by the engineer or the contract administrator? So on the common law ground, as far as the common law is concerned, the contractor has only the obligation to the work that he has contracted for, not others. So the variation is a special clause that comes in so that the contract is still intact. Meaning to say, they allow the employer to somehow intervene. Now that answers Rida's question, yeah? they will come in to intervene by saying, okay, now I decided to extend the road, to somewhere else. So I don't mind paying the extra. You have to do it. So the contract has shifted the risk again in this sense by keeping the original contract intact and yet allow the employer to do the variation work. You see? So now the contractor is stuck in between. What to do now? So the FIDIC's answer to this is very, very interesting and it's very novel as well. I will explain that. But for the purpose of discussion, I was just telling Rida, it is very, very straightforward for a traditional procurement, but it's not straightforward for the design and build. And I'll tell you why.
Oh, okay. Well, Jeff in the chat say variation is good because it increases the value of contract. So maybe we'll go to the next one, which is okay. Let's say, David, with a design and build contract, can the engineer issue variation to the employer's requirement?
That is where I'm going to come. Let's just say in the design and build. Now, what do you mean? What do you understand from the design and build perspective? Basically, design and build, it just says that you leave everything to the contractor. You just tell the contractor what you want, right? So you better fix up your mind first. You say that, oh, this is what I want. The rest, contractor take care of. That itself is an agreement. Okay? You have an agreement between the employer and the contractor. In that particular agreement, it's stated very clearly, the requirement of the employer is made known from the onset, and what happens next is to be taken care of by the contractor. Suddenly, you come out with this variation. You are actually adding something to an agreement that both parties has already agreed. And more importantly, in this kind of context, can the administrator or can the engineer actually issue an instruction of variation in that nature? The answer, if you do so, you are actually changing the content of the agreement between the two parties. Where on earth can a consultant do that? Change the agreement between the two parties? You can't.
Yeah, that's true. That's true.
You see that or not? You see, it is easier for the traditional, but when it comes design and build, it's totally different. You can't. So the correct way to do this is actually the employer has to get the consent of the contractor, and both of them enters into a supplementary agreement to allow such additional variation to be taken into consideration as into the employer's requirement. You see? Then only the engineer is empowered to give such an instruction.
Yeah. Sorry. I think that answers the question on the floor. Okay, let me just repeat the question on the floor because this is a new question. So thank you, Masniwati. In an amended FIDIC, if the engineer, also known as the contract administrator, does not want to issue instruction as per employer, and the employer can't terminate the engineer without a consent from the contractor, how do we move forward with this?
That's the beauty of it, because in this kind of situation, you can really see how professionalism actually comes into play. You see, so that gives confidence back to the contractor. Actually, if he sees that mine right now is the shift of risk now go back to the other person. Somehow or rather, now I could see that the engineer has made up his mind and he thinks that this is the correct way or the correct thing to be done. I respect him, and there it goes. The work still continue.
Okay, great. Thanks.
Yeah. I think just now, David, you put it right when it comes to variation, that instructions, the parties must be agreeable together. After all, the contract is between the employer and the contractor, right? So, but now, currently during pandemic, a lot of employers or contractors are having financial issues. What do you think about this?
Yes, that's the interesting thing, you see. So on one hand, let's just say the employer decided ask you to do extra work. Then on the other hand, he haven't even paid you for the first few claims, you know. And the other hand, you also find that he's in financial trouble. So what's going to happen next? Now, this is a very, very interesting thing, because this is also one thing that the contractor can allow under the FIDIC to get the information from the employer saying that you asked me to do this additional work, no problem. I will attempt to do it, but you must first show me that you can afford this additional work to be done. So you have to you reverse the risk to the employer, asking, can you prove to me that you have sufficient fund to allow me to continue with this additional stretch of work? You haven't even paid me for the rest of the claim that I put to you. Very interesting. Now the employer has to prove to the contractor that he is financially able to actually require the contractor to continue with this additional variation of work. Very interesting, right?
Yeah, very. I mean, like from your experience, how does the employer actually prove this? I'm curious. To know.
In the form, if I'm not mistaken, it's over 28 days. The employer has to give the financial statement to prove that he's financially able to carry the task. Now, this of course open up to another dimension of argument. Now it's like the employer is standing naked in front of the contractor. You know, I have to show you my financial statement, where the money come from, and how the money is going to be expended. You know, there's sort of dynamics that comes in. You know, then how would the employer actually react on that? That is very interesting. That is forthcoming. You see.
Is there like from your experience it's like a mechanism of escrow account where employers put into as escrow to prove that? Is that would be easier, or just
no? It's not the question of trust.
Yeah.
It's the question of is in the contract that the employer has to prove that he has the money to finance the variation.
Just simply proof lah.
It's not a trust. You don't have to put the money into an escrow account. It's just to show that. So you relatively have to issue your audited finance.
I see. As simple as that. Yeah. Okay.
And also, how will you, if it's under loan, how are you going to get the loan to actually, or finance the loan to actually move forward with the project?
Right. Okay, David, let's continue the next question. If the variation involve illegal operations. So what say you?
Let's just say that this variation involves doing something in a very sensitive area. Let's just say the highway, actually now you want to extend the highway, crosses a very a forest with a lot of biodiversity, and there is a very unique crocodile that lives there. It happens, right? You know. So
yeah, something like that, yeah.
So the employers will tell you, just bulldoze, you know, I don't care. You have to do it, you know. So very interesting about
really?
Yeah, assuming you know, you get a nasty employer who give you this kind of direction. So in the FIDIC, it is stated specifically that you have to take into the question that you have to follow, as a contractor, you have to get the necessary approval from the local jurisdiction. You cannot breach their law, and so this is the obligation as the contractor. And there is also a special provision that in the FIDIC that they want this job to be taken to consider environmental friendly. Right.
So if you have this obligation.
So if you have this kind of nonsensical request from the employer, one thing, because of saying that, now instead of terminating yourself, in this FIDIC, you are given a chance to suspend work. You see, in the normal common law jurisdiction, once you have accepted the work, you cannot suspend. The moment you suspend, it is your wrongdoing. But the form allows you to suspend because of all this kind of thing that comes into it. You see? So there is really what we call the balancing of the risk here.
Yeah, I mean,
I see.
some of my friends, David, last time they were doing projects highway in America, the States, working in the States. I mean, your example is quite similar to them. Like their project, they found a very rare flower. And then one of their project, they found you know, bear in the tunnel. So that leads, because the bear is hibernation in the tunnel, so that leads to they have to stop the work because it's against public policy for them to affect the environment.
Yeah.
So like the rare flower, they had to wait until 6 months after just to get clear to do the construction.
Well, this is coming from good experience where you have to wait until the hibernating bear actually woke up from his sleep and then and then move it somewhere else, and before you can continue on with the work.
That's what happened in my friend's project in the States. Yeah, but anyway, this leads to when such incident happens, it leads to a loss of profit to the contractor because of the delay.
Yeah.
What's your comment on this?
Okay. Now, if this variation involves a loss of profit, now this loss of profit, we always talk about the loss of profit that is annexed to this particular project itself. But let's just say because he has to take your variation and continue with he may experience loss of profit from some other project that he intends to embark, right? So can that loss of profit somewhere else be actually accounted for in this particular project?
Obviously
the interesting is there is a provision which is capped. There is a cap to this particular damages if it does really occur, you know. But the full force of how this thing is going to be operated is still subject to be seen.
David, right? You know, this is the common challenges, from us, yeah. Yes. Another thing, as David, it is a very common, I mean, the employers sometimes they're not giving a prompt information. You know, what if the variation incurred when the information provided by employees is wrong, for example? You know,
okay,
this is very common. This is very common.
Yeah, it's very common that in the sense that, for example, in the local scenario, whereby they always wanted to park the risk of the subsoil condition back to the contractor. I mean, relatively, anybody can't see what is hidden below, right? So if you want a job, you take that portion away, you know, as a design and build kind of thing. You absorb the kind of risk. So if anything, you have a hard rock or you have a cavity, that is your problem. It's no longer my problem. That is very common, you see. So this kind of situation whereby, so from the onset, let's just say that the employer would have given the SI report to the contractor. Now, the normal thing or the right things to do is that the contractor will have to look at this SI. This is the due diligence before they accept the tender, right? They're supposed to come up with a proposal. So they have to base on this SI that's given to them by the employer. And let's just say that this whole stretch of road, 300 kilometers, from the SI, you know, SI sometimes they do sampling and they found that there's actually no rocky structure. Then you do your economics of scales and your computational of the cost. I find that you can actually do this with this X amount of money, right? Then suddenly, what happens is during real construction on site, you found that between these 300 kilometers, there is one very small portion of the road actually contains a lot of rock. And intermittently, not only that portion, along the 300, there are certain portion of road also containing rock. Then that incur additional cost to you. So the contractor on one hand will blame the employer saying that your SI report is inaccurate. So now with that, I am entitled to additional claim. So how? So as a contract administrator, the normal choice of things that comes in is basically the engineer will insist the contractor to absorb the cost, citing that in the first place, they fail to verify prior to the acceptance of the tender. Am I right to say? So this is the normal situation. But think about it. Yeah. In the FIDIC, there is certain information is to be provided by the employee is stated in part of the conditions. So if there is a condition that if there is a discrepancy or there is wrong data, the contractor is entitled to claim. Okay, but remember, there is also another condition. If the discrepancy account less than 3%, then the contractor has to absorb.
3%.
Yeah, 3%. Because the accuracy of all our equipments today, the modern equipments today, the closest you can get is the 3% of error, right?
Yep.
So if you have done the 3%, then I think if the rock that is found in the intermittent of this 300 kilometer road is accounted is less than 3% of the entire distance of the road, then it's very natural for the contractor to absorb the cost.
Makes sense.
Beyond that, of course, the employer has to pay. So that is how the shifting of the risk comes into play, the dynamic of it.
So yeah. Okay, David, we backtrack a bit since we have a question from the floor, from Gulam. Okay, so just now under the design and build / and lump sum contract, let's say during the post-contract stage, can the employer omit any front-loading item? Let's say the front during the early stage of the contract. Okay, specifically when the contractor submit a claim related to the same item due to meet to the requirement of specification.
Okay, can you repeat again? It's a bit detailed in a sense.
Okay, I'll try to simplify.
I have to sink into the scenario that this questioner has.
Okay. I will try to simplify the question from Gulam. So let's say a design and build contract.
Yes, yes.
During the post-contract stage.
During the post-contract stage, okay.
Yes. Can the employer omit any front-loading claim, which is like the early stage front-loading item, especially when contractors submit a claim related to the same item. So let's say the end of the contract and the early contract is the same item due to meet requirement of specification. Not too sure what is this, but anyway.
Okay. If I get the question correctly, you have to understand how the mechanism of design and build works, all right? The employer is basically concerned with his requirement. If let's just say there's no change in his requirement, right? The contractor will have to come back to him saying that this is how my building looks like, this is the schedule that we are going to complete, and this is the cost, and there is a breakdown of cost how it's going to be done. Once that is accepted, post-contract, you can't change the goalpost anymore. Because the fundamental philosophy of design and build is that your biggest concern is to fix as an employer, your employer's requirement, what the deliverables are by the contractor. So if you have already pre-agreed that this payment is going to be by this milestone or by this this installment, you will just have to oblige. If you disagree that, then before you accept that, you have to put in your requirement. Okay, I don't want front loading. I have to be back loading because this and this and this and this and this and this.
Yep. So set things up front.
Yes, you have to set things up front.
Okay. Yeah. Thank you. Gulam, I hope we answer your question.
I have a question from Facebook. Yeah.
Oh, another question.
Yeah, interesting. So this is quite interesting. This question is there was this incident in Malaysia on you know that when a contractor design build an apartment, so they are supposed to also deliver together with the subdivision of title. So everything is cost in within the design and build contract, right? So recently there's a little bit of issue because all the design and build contractor did not cost in together with the architect's fee for the strata. So this become a very big dispute. So from your opinion, David, should this be absorbed by the contractor because in the design and build is already inclusive of title, or it should be borne by the employer?
Yes. In this kind of issue, you see that now this is where the dynamics come in when there is a change. There is a change of jurisdiction. The strata fee that is to be accounted for to the architect was actually, there is a change in terms of the requirement, right? In the fee, if the FIDIC were to be applied here, that change of the jurisdiction or the requirement has to be accounted for. And in that sense, where there is not a pre-agreed by the employer before the job commences, it will be absorbed by the contractor. Because remember, in design and build, whatever things has to be agreed in the very beginning. That seals the agreement. Whatever comes later on, that is the contractor's problem.
Wow. Oh,
Interesting.
interesting, David.
Need to factor in all before we sign the deal, eh?
But then you can't see the crystal ball, right?
Yeah, cannot see the crystal ball, yeah.
I mean, that one is redone. That one is a design and build, isn't it?
Yeah, design and build, yeah. It's like, you know, it's totally mind-blowing.
That one design and build. Okay, okay. Continue, David, continue. I think we're running out of time now. We're 4 o'clock already.
Is it?
Yes.
So
Yeah.
fast, yeah.
4
Okay.
o'clock already.
So can the contractor avoid this, and on what ground? I've just told you the ground just now. That is the 3% you can't avoid. You will just have to absorb. So whatever more than that, then of course you can compensate that. So what if the wrong data consider 2.9%? Wow, this is like splitting hair, you know. You know, people can argue what if it's 3.1% and not 3%? You know, this is splitting hair argument. So this kind of parameter that you put into the contract may come to this kind of argument in law, you know. So I have no idea about this. I cannot really say much about this. So what if the situation involves a highly technical work beyond the competency of the contractor? Let's just say you build halfway, you find there's an entire Mayan civilization buried underneath the highway. What are you going to do? You know, so this is beyond your competence. I'm only normal contractor. How can I deal with this Mayan civilization, you know, buried under the highway? What is going to come out of this? This is something. This is something to be considered, you know. So next, of course, we talk about if everything fails, is there any ability to discharge? Okay, so I think this will brought up to a next big topic is discharge of the contract. Okay, so termination is this by which way? Of course, is both way. If the contractor can terminate himself, or the employee can terminate the contractor. So it's both way. But of course, there is a specific procedural method to be taken care of. And the damages, any limits? Yes, they do have a cap for the damages. And if everything fails, what are the dispute resolution? So, like I say, for the rate form, basically is the engineer will be your first stage. It's a multi-tier. The engineer will be the first stage, and then if you're not satisfied with what the engineer has determined, you go to the next stage. Next stage is basically by mutual, what you call the mutual consensus. Okay. Is roughly like a mediation, then before you bring it further into arbitration. And very interesting things about this, if let's just say you are really seeking for finality, certain forms will have what we call the dispute boards, whereby first you have to be adjudicated by the dispute boards. All right. Then if you are not satisfied with the decision, which is actually not final, then you can bring it a step further, which is arbitration. And of course, arbitration, there is finality. The question now will come in is, if the party goes into arbitration, which is the law that follow. Because in the international context, you can actually follow any particular law. It's the choice by the party. But strangely, in the old form, the English law is the one that has to be applied. But since then, because they know that this form has been used widely internationally, they have taken out, that becomes international. You can choose your jurisdiction. And what is more interesting is that the rule of arbitration, they follow the what you call the ICC rule. Now, let's just say that this matter goes into arbitration and there is this ICC rule that you follow. Suddenly there is a change in the ICC rule. ICC rule says that only ICC administered arbitration can use ICC rule. How?
What is ICC rules? What is ICC rules, David?
International Chamber of Commerce. So they have their ICC court, of arbitration. So only ICC administered arbitration. That means you have to go through your court system. Then only you can use this ICC rule.
Okay, but David, it's dependent on how the FIDIC is drafted of use of the country, right?
Yes, that is how it's drafted. Now it's drafted that the arbitration rule that is applicable has to follow the ICC rule.
I mean, if you don't change anything, ICC, you go to Geneva to arbitrate the ICC.
Yeah.
But I mean, if not, I think a lot of the FIDIC use in a
user may change.
User may change to the particular local place lah.
That's correct. Okay, just let quickly go through the dispute resolution multi-tier. You have to have adjudicate before the dispute board. Then there is something called the amicable settlement, and also lastly your arbitrations. Yeah, so this is how it's being structured. And if there is any dispute in terms of consistency, this is the order that you follow, the documents. And of course, next we'll come to this NEC, which I promised you earlier. This is one of the very interesting things to explore. Okay, and to really understand this, I just need to tell you a story. How do I actually come to know this form? Okay, back in 2001, I attended an adjudication course in Hong Kong, whereby they are actually using NEC and it was promoted. At that time, to me, it's a fairy tale because with the old paradigm that I have, I simply cannot accept NEC. All right, and I cannot believe that. So one of my friends actually brought the trainer back to Malaysia and introduced that to MBM is our institute that we call it a contractors club, right? RADA is the institute that represents the developers of housing developers. So they were introduced to these two bodies and hope that they can accept this form. Unfortunately, he was ceremonially given a boot. In Malaysia, it's still not the time yet to take this particular contract. So why? You tell me why. All right, now dealing with NEC is that you requires a total mind shift. You cannot hold back to the old way of thinking. You cannot see your contractor as an opponent. You must take your contractor as a partner. All right, so there is a totally mindset that has to come into your mind. So get to know this angel and you will begin to fall in love with it. So I begin to try to, by throwing every baggage I have, look at it as a new, understand it, understand how the mechanism works. Then I find that there's actually beauty in it. Now, basically, the structure of NEC is different from the rest of the contract that I mentioned earlier. Different. They have this thing called a core process. Core means to say that is the fundamental of everything. Then in this core process, there is the main option. One book by itself, There's the ADR option, another book by itself. There is also a secondary option. There is a schedule of costs and also the contract data. This is how they break it down. So that you change one thing, you don't have to change the rest of the thing. The rest of the thing can maintain as it is. So this is quite, they try to make it even using very simple English. Okay. Now, what is in the core process? The core process is telling you about the general process. Like for example, if there's a delay, what to do, blah, 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 Then there is where it tells you the main contractor's responsibility, the time, how to do the testing, the defects, the payment, and this is the classic of NEC. Compensation event. They don't care what is happening. The moment you find that there is an event that needs to be addressed and that particular event needs additional payment, it all goes into this compensation event. You can see the paradigm shift. All right. And then there is something called the title of plant and materials transferable. And there is an insurance risk provision. And of course, there is a termination provision. That is core. Then now look at the compensation event. Now, number one, there must be a notice. If you find that there is a delay event somewhere else, okay? So the contractor has to raise a notice. Then when this notice is raised, he will have to give you a quotation how much it costs to mitigate that. Then if it's accepted by the project manager, done. Case closed. So the moment, if there is a delay event, he raised a notice, that is the moment where everybody have to sit down and crack their head, get the solution done. If he finds that in order to move ahead, this is the money that he has to pay, he will say, go ahead with that and move on. You know why? Because end of the day, if the contractor is able to put in costs, we call it cost engineering, and save a lot of money from the project, the profit of saving will be distributed equally between the employer and the contractor. You see, there's no penalty involved. There is only collaboration. There's no you, me, there's only we. You can't say that the cabin of contractor is actually separated into two compartments. One is the consultant and one is the contractor. No, all work together, all share the same drawings, all share the same roof. So immediately, if there is an issue, kick to the what you call to the meeting and resolve it there on, and therefore decide and move on with the project. This is the overriding principle of using this particular form. So that's why there is this early warning. The moment the contractor feels that there is something buggering him, you know, it may be delayed, he immediately have to issue the notice. Of course, there are certain things that is in the form I already say very clearly, the disallowed costs, like repair of defect, unjustified site records, blah, blah, blah. These are reasonable, you get what I mean? Beyond that, is subject for the decision of both parties actually. So the main option is actually cater for your route of procurement. Some decided it has to be lump sum, some design and build, and so on and so forth, right? So this is where it caters for under the main option. And under the main option, B is the price contract with BQ. C is the target contract with activity schedule. This is like your contract management procuring, yeah. And also D is the target with BQ. So they allow you to have all this procurement within the use of their form. It depends on what you want to choose. And E is the cost reimbursable. That means to say you factor in your profit margin, the cost that you spend. So you can see how collaborative that form gives you, the options that the forms give you. Of course, the NEC 4, which is the upgraded version, has got this management contract. Yeah, and you know, it's open book. You can anytime actually go and see the contractor's expenditure. The book is open for you to check. Similarly, the contractor can come to see the financial arrangement that you allocated for the project. Okay, and this also, the item G will include in the consultant's cost, because in NEC it's not unlike the traditional where you have the consultant. No, the NEC, the employer, then you have a different players as the consultant. The contract administrator is the project manager. Then you have the supervisor, which is constitute of architect, engineer, QSs, and so on and so forth. The technical people are now classified as the supervisor. So the supervisor will have to take the cue from the project manager if they were to call to determine the quality of certain thing. But then they are not required to determine extension of time or variation or something like that. That will be the role of the project manager. Then on top of that, there is another bunch of people called the ADR people. the dispute resolution people, the adjudicator. So if there is any issue, the moment it arises, you don't have to wait for the project to complete. Anytime there's an issue, our adjudicator stand by to adjudicate. And once it's done, move on. Right, it's very interesting. So these are the things. So the ADR options you see consists of there are two options in the version 3 version. Then we call this the W1 option, which is the standard option for ECC. The W2 is the ADR that applies to UK. Right, so UK has got this HGCRA adjudication, so they have already arranged to do that. Then W3, which is in NEC 4, is dispute avoidance board. This is for international ADR. Of course, the form also allows you to change some of the clauses. So there are these the 15X clauses. All right, so you have to take into consideration inflation, change in the law, currency, blah blah blah. And these are the things that in the X option clauses, which you can take away or you can remain as it is. Then there are these Y clauses which talk about financing, okay? And also the Z option is actually you can rewrite the entire contract if you wanted to. So whatever happens or be written in the Z clauses will take precedence over what are the one that is written in other options. So they allow you to tailor suit your NEC. So once that happens, your NEC is no longer NEC but a bespoke contract. So a lot of time we try not to touch the Z clauses. Okay. So there is a schedule of cost component. Yeah, this is where you can see that the employer actually tell you from the onset that this is where the cost is. Okay. And the contract data will be filled in by the employer and the contractor. It's just to tell you when notice has to be made. You know, it's just the timing issue and all these things has to be spread out in this list. Then this NEC 4 has added forms for the ECC and also the subcontract and also the watered down version of the ECC and also some professional service. That means to say you can use NEC for your professional engagement. Okay. So these are the new things that comes into this NEC 4. I think I will not go through this. All right, so this is an introduction to what this form is all about. So this is really based on the partnering approach. So everything has in the NEC, you're supposed to put in a very big title there saying that spirit of mutual trust and cooperation. So that everybody will remind themselves, we are operating under a different system. Here, there's no you and me, there's only we.
Amazing, David. This contract is like, you know, like when we get married, there's a lot of issues everyone face, and then learning from the issue, put everything holistically into one contract.
Yes.
Amazing.
It's amazing. That's why I say it's quite a fairy tale in a sense, yeah.
Yeah, it's quite fairy tale because can you trust each other or not? That's
Yes.
the big issue.
Yes, that's why to make this thing work, the party will have to make mutual commitment, you see.
Right.
And then there is a very compliance to the contract procedure. It's very procedural. So if everybody plays part, then I tell you this is perfect.
Goodness.
Then there's no such thing as consultant cabin or contractor cabin. Everybody in the same cabin. And the attitude is the team player, not master and slave. And
as one team.
Yes, it's one team. So approach the goals that set up and start from mutual respect. So you cannot practically can't shout during meeting, right?
Interesting, yeah.
David, there's one question from Jeff.
Yes.
Hi, David. So far, are you aware if any company in Malaysia is using NEC at the moment?
So far, I told you just now, there is an attempt to do it, but he got booted out.
Really?
Yeah,
Not that easy, yeah.
I mean, David, to declare with you, like myself, I'm exporting my service as a conceptual design architect, many countries. It looks like I never got a chance to admit the contract. You know, if if I got a chance to like have a project in Pakistan, I might call my good friend Dr. Malik Tasaduk Abbas Malik to to come and collaborate with this, to look into the contract administration, contract buildings, or maybe I just call expert my good friend architect Amir Pal. Is very good in the contract matters, So, but I need your opinion, because those building contract that you have shared just now, compared to ours like JCT, what happened if we can collaboration with among us as a team and then work together? Well, I need your opinion. Yeah.
Then I think the NEC approach is much better because you're talking about collaboration. But you can't have half of it is the adversarial type, and then half of it is the partnership type. You are asking for trouble. You have to decide and choose.
That's the thing.
Yeah.
Yes. Because you say there a spiritual trust. A spiritual trust.
That's why this form is the overarching principle is good faith. I can tell you it's a new in thing. I think the Middle East actually employ these forms, So I think they are very much advanced with this form, especially in their mega project that's happening there.
Yeah.
Something that we need to reconsider very seriously in our industry here.
Yeah, I like the way Adrianta was asking the question, David, just now, because when we talk about export service, now we are exporting design and then going to abroad, and the contractor, local contractor, the architect will actually take over, right? But we do know that when we do design and build, there's checker, then there's the checker architect, and also the architect is under the contractor. But if we know this knowledge, we can actually become as a checker, come the contractual checker as well. We can provide that service.
Yes, your service that you provided in this form, if this you are adopting this form,
that's the thing.
You are playing the role of the supervisors. Let somebody just play the role of the project manager, because he will have to do the daunting task of day-to-day work and things like that.
Exactly.
The local in that particular area will be the best people because they know the situation, they know the constraint well. Why are we architects, if we are exporting our service, want to muddle with this kind of situation, right? So you only want to control the qualities and things like that. I think this form allows you the role to play.
I see, yeah.
Okay, so the mutual trust and cooperation basically tells you, just now I quickly say the role, like just now, what is the project manager, what is the supervisor, so I can skip this entire part of the thing. So now, how the mechanism, how it works, now in the event there is a potential delay, there is a difficulty and impact onto the cost and time, which are not foreseen. Like for example, now COVID issue, but they don't call it force majeure at all.
No.
They lump everything into this, what you call the unforeseen event, or the delay causing event. They just call it by a different term. Okay? Immediately, contractor must give early warning. You see, early warning is very, very important. Where he applies foresight, the contractor will come to tell you, Mr. ABC, this is the issue I'm facing. This is where the problem is going to come in. Okay? Because if he failed to raise the early warning, he cannot claim later. All right? So now mitigation sometimes may involve acceleration, In the older form of contract, whereby adversarial approach, if the contractor accelerates, you pay for the cost of acceleration. But in this case, if the acceleration does happen, it is on the account of the contractor. Why? Because if he can save costs, part of the saving will also go back to him. So there is really no question if he wants to mitigate by acceleration or not. That is the beauty of it, right? So there is this thing called the risk reduction meeting. So anytime the issue comes in, they will go into this risk reduction meeting, talk everything out and decide what is the best way to go about it. So they have this risk register whereby they will enter what are the ones that give risk and how to mitigate it. So it's actually in another way trying to tell you that this is a risk management system inbuilt into this contract to avoid future dispute. That's why I say the entire contract is being drafted in the sense that they're trying to avoid dispute in the very first place. Okay, then when the event is really a compensation event, now compensation means that it compensates the contractor. Then there is mechanism that allowed this thing to happen. Okay, so the details I will not touch on it. And once this thing is being decided, the program is not a fixed program. You know, there is actually no such thing as the end date. It can actually move faster and it can actually move shorter. You see, so once the program is a living program, it keeps on changing. So once there is a delay event, is accepted, is a cost compensation event, then the program will be adjusted accordingly, and ultimately the contractor will have to do their submissions and so on and so forth. And now the issue with NEC 3 and 4 is like, for example, if I've done this program, I submit to the project manager, and if the project manager didn't say he accept or he reject, how? So there is a deeming clause in NEC 4 said that if you didn't comment anything, it's deemed to be accepted. You know, things like this. So it's an improved version, you know. So this is how the compensation events that requires a variation, the instruction for quotation has to come in. The contractor has submitted the quotation and it has to be a reply from the project manager, failing which notification. Otherwise, the project manager will accept the quotation and carry out his own assessment. And if there's a prolonged silence, it's deemed to be accepted. So this is how things move. So assessment you can read, this is the criteria. Everything is procedurally inbuilt in the forms. All right, for all intent purposes, the core value of NEC via the mutual trust and cooperation spirit vested in dispute avoidance. Okay, so any issue arises will be quickly resolved via its risk reduction meeting, and the risk register is constantly updated, and the accepted program is constantly reviewed. And that's how they move on. Okay, so let's just say that for all these reasons, there is still got problem, and this is how the problem may come in. Yeah, I won't go too much on this. Then the NEC 3 provide you two options for dispute resolution. One is where unless the adjudication requirement in UK apply, one is for the UK purposes. Then this is based on NEC 3. Then if not, then there will be an adjudicator to adjudicate this by first independent third party, named in the contract and agreed. Where dispute arises, the appointment under the DRS contract with subcontract joiner possible by agreement to adjudicate over the dispute under the prescribed rule. So they say everything very clearly in this form. So unlike the NEC 3, NEC 4 actually changed, whereby now they encourage mediation, whereby the senior representative from the two companies actually sit down and strike a win-win situation. You see, so this kind of thing, this kind of mediation role, of course they don't call it mediation, they call it a senior representative. Okay, before you actually goes to other more damaging way of dispute resolution like arbitration. Okay, so this board, the dispute avoidance board. Okay, so they have this board that can set up to quickly resolve this under the clause W3. So that's it. We come to part 3. Hello.
Wow. I think my mind is like blown away. There are so many things in NEC contract. Okay.
We have reached 4:30.
Yeah, we have reached 4:30. So maybe those who are interested in David's talk, Lab will organize a talk. Maybe let's project the Google form for registration of interest. Is that okay? Is that okay? Organizer? Yeah. Maybe An and Vida. Okay, maybe we'll just put it. Okay, Sorry guys, just to interrupt a bit, for those of you who are really interested in what David has talked about just now regarding FIDIC, NEC, and more contract types. So Lab is planning to have a 2-day workshop on the forms of building contracts. So if you're interested, maybe you can grab your phone out now and scan the QR code, or maybe type out the forms link on the screen. So we know you're interested in this, and we will try to organize something. David is very knowledgeable in different types of contract. I'm sure you guys agree, because this 2 hours have just passed by or flew by.
Like that.
I'm
just like that.
Confused. I'm just very, very confused. So those of you who want to take your knowledge to the next level, feel free to scan the code now. We'll just leave the screen on for maybe 3 minutes because hype. Meanwhile, An,
yeah, I mean, it's a truly informative until the time flies like that, 2 hours like that. In fact, David also have more to share. I think Rida, we should make a decision if we got a good response. I think we should organize a special workshop regarding this matter. What do you think?
I agree, An, because today's session is actually to give an overview of what are the available contracts internationally, from FIDIC to JCT to NEC, and then relate to your practicality of your projects. At the same time, David gave an overview of the construction contract management, right? So that's, I think, is a good starting point to the next level. Yeah.
Correct. I mean, this is a gateway for our generation architects now start to thinking to exporting the service.
But I think later on, if you are interested, you can join the workshop. David will actually share in terms of the experiences, the issues, the different type of challenges in the projects. Yeah, Adrianda?
Yeah. I think to be fair, Esmond, if you don't mind, to be fair, that we got one more question from the chat box here. I think can we just share to David, and then he can share his opinion to answer this. Then we can wrap up. Yeah, we can wrap up the things. Okay, let's go.
Okay.
Okay.
This one is from Shah Rizal. Thank you for your question. Although it's like half an hour late or 15 minutes late, but never mind. I'll read out the question. So contractor and employer enter into agreement and agreed on items for prerequisite for practical completion. Okay, so the items listed for prerequisite. However, once the project is physically completed, some items in the prerequisite has yet to be completed or submitted by the contractor, but the contractor asks for CPC. This is very normal, okay? So contract administrator doesn't agree together with employer too. So contract administrator is with employer. So contractor bring for adjudication and won. Wow, this is a scenario. This is quite an interesting scenario. So does this mean the contract earlier agreed can be challenged even though both agreed at the first place? Yeah.
There are two facets to this question. Number one is the true meaning of completion, the true meaning of practical completion, and the second facet is that when this matter was brought up to adjudication, it really depends on how the case is being argued. Okay, so I could not address the second one. I could address briefly the first one. Now, if I could understand clearly, there is a list of things that the party has agreed to conclude before a practical completion is obtained, right? Now, there are two things here. Number one, what is the real meaning of practical completion? Actually, practical completion has got no peculiar meaning. There's no meaning at all. Only the contract gives meaning to this term called practical completion. In the FIDIC context, is the substantive completion. Now, in a nutshell, it just simply means that to the opinion of the architect. If the opinion of the architect states that it is practically completed, so be it, it is practically completed. Okay, so that is the meaning of practical completion. Now you add another things into this notion of practical completion. That is the list of things that to be completed, right? So if this list of things that ought to be completed The question is whether this list is binding or not. And how exactly is that particular clause in your pen form is being drafted against this list? And if there is a conflict between this additional list with the pen form or the pen condition, which take precedent? You see? So there are many things that can go wrong in between. And that really depends on how the counsel really argue his case over. You see, so but that information I have no privity. So really we cannot say anything. Anything can go upside down or inside out during an adjudication or an arbitration. I hope that helps.
Yep, that's a very good answer. I hope Shah, you get your answer here.
Yeah, I mean that question is very, very interesting, David, because it's based on what are the circumstances of the prerequisite requirements and also the documents there, right? Whether it makes sense or not.
Yes, yes. True.
Sometimes prerequisite requirements doesn't make sense. Yeah.
I mean, this is a good session. It's a wake-up call for everybody, you know. I mean, for me, I would like to say to everybody, it's like a gateway for us, you know, thinking about to how, you know, start to exporting our service out of Malaysia. I mean, it's a very informative, David. Thank you so much.
You're welcome. You're welcome.
Thank you for your time. Actually, thank you for your sharing.
It's actually that I'm a bit sad that I could not go through the journey. You see.
Yeah, it's okay. Because 2 hours, I think that's enough. I think we shared the form here from the screen. In fact, in the Facebook, I hope the organizer can post it the form as well. So we need the feedback from the attendees. Yeah. Whoever interested to know deeper about this, I think Rida and myself and the organizer team will thinking to organize a workshop. Yeah.
That time, David will share not only the journey, but a lot of other journeys, also the challenges as part of the administering this international contract.
It will be whole day.
It will be yes.
Not whole day, 2 days.
2 days. We're gonna be making it 2 days if possible. I mean, let's make it suspend up to the journey and then let's see how. Yeah, I mean, what's the continuity?
Yeah.
Very well, very well. Any last word from you, David?
Hope to see you guys if you guys are interested. And I think it's good to spend more time in upgrading our knowledge in this kind of situation. Crazy time, you know, everybody's being locked down. And I know that the other part of the world is opening up. Yeah, so one fine days, I think we can continue on with physical training rather than just virtual. That's all I have to say. Thank you very much for your time spent.
Maybe I'll wrap it up.
Thank you so much. Thank you so much, David.
Okay. Thank you, Adrianta and Rida, for supporting me. But most importantly, thank you, David, for giving his time, knowledge, and a generous sharing session from the different types of contract all the way up to journey. Yeah, just the journey. But we will keep that for next time. So as what David highlighted, it's a very good time for us to learn different knowledge, because we foresee that in the future there will be more and more contract disputes because a lot of conflicts are happening, and we tend to go borderless in the future. So I hope everyone is those who are interested, do sign up so we can organize something for you guys. And I'm sure everyone agree that David is very, very knowledgeable. So thank you once again, the lab management. Really, really grateful for his presence and the slides, everything, all the knowledge. You can rewatch all the recordings on Facebook. So, if you're not too sure like me, I'll probably replay it after this.
Definitely, we were going to watch again, Again?
Okay, by the way, can I request the organizer for me to share this, my contact, if anybody want to contact me?
Sure.
Can I share the screen?
Yeah, please.
So anyone who wants one-on-one tutoring, or just go to David directly. His contacts are all here: the webpage, the Facebook, the LinkedIn, the email. So take a picture of it, save it. Don't worry, it's also recorded on Facebook. Go towards the last few seconds of it. And I want to thank all of you, especially the 100 105 on Zoom link, and those not forgetting those on Facebook. Thank you for your time, spending the precious Sunday evening with us. We hope that we gave you knowledge, to take your adjudication or contract form to the next level. Okay, I think that's about it. I hope you guys stay safe, stay healthy. Just try to stay at home. That's the most important thing. Okay.
Please reduce the numbers. The numbers.
Yes.
All right. Thank you so much. Have a wonderful day, everybody. Thank you.
Thank you, everyone.
Thank you, David.
See you guys soon. Bye-bye.
Thank you, Reda. Thank you, Esman. Bye,
Thank you,
everybody.
Bye-bye. Bye-bye. Bye-bye.
Bye.
Wonderful. All right.
Amazing.
Amazing. Okay, Herman. Now it's yours.
Okay, how is it? How is everything?
We need
Okay.
some songs now.
Cool? Interesting?
Interesting. So, okay, hold on for a while, David. I think we just mute ourselves and then stop our video until finish recording here. All right. Okay. We'll see you later.
Power on the beat.
Amir Pal, are you there, Amir Pal? Ninkan, Masniwati, Azizi. We recording, still recording, guys, kan? Ilman, are we still in the Facebook Live?
Off.